So we're discussing the Bill of Rights, and one of the major concepts in the Bill of Rights is the concept of due process. This is the second video in a series of 4 devoted to due process, and this video is specifically addressing the wording and meaning of the Fifth Amendment. If you are watching this second video in the series on due process, if you've already seen the first video, which is on the Fourth Amendment, you can probably get away with skipping the first 6 minutes or so, the first 11 slides, and jump ahead to the 12th slide if you would like. It might be helpful to have a copy of the Bill of Rights with you. It might be helpful to have this 23-page packet full of Supreme Court case summaries that you've been provided with. It might be helpful to you to have this one-pager that you've been provided with that lays out the entire concept of due process from beginning to end. It's really good to have that understanding of due process, so you don't just focus on the words due process that happen to be in the Fifth Amendment, and you understand that the concept of due process is scattered across several amendments and other places in the Constitution, and isn't just associated with the trial, but also concepts before and after the trial. And it would also be helpful to have this page of due process related Supreme Court case decisions that you've also been provided with. The phrase due process refers to all of the rights that are due to you. That means you get them. The government is required to respect these rights that are necessary for you during any sort of government process that affects you. Any sort of process means procedures or steps that the government takes when it makes decisions about you. And usually when you're talking about due process, you're talking about the legal or the criminal process. The government is deciding whether or not to lock you up or punish you in some way. So maybe one way to summarize due process is all of the necessary steps that government must take in order to punish someone, or in other words, all of the rights you must receive in order to have a fair trial. For this reason, sometimes your due process rights will also be referred to as the rights of the accused. And as the chart that you've been given tries to illustrate, your rights as an accused person, your rights as a citizen, your due process rights begin well before a trial. They exist before the trial, they exist during the trial, and after the trial. They are referred to in several places in the Constitution and by several amendments in several places in the Bill of Rights. For example, if you refer to the due process rights and related cases handouts you've been given, you'll see that your due process rights restrict the behavior of the government even before you are arrested, because in order to arrest you, the government must have something called probable cause. Probable cause based on evidence it has already gathered. The gathering of that evidence is pretty much the rules for gathering evidence are laid out in the Fourth Amendment, where it says you have freedom from an unreasonable search and seizure. So the government must conduct its searches or seizures of property or evidence in a legal manner consistent with the Fourth Amendment. Those cases off to the right there, don't worry about those. We'll discuss those later in the video. Your due process rights are also in effect after you've been arrested or taken into custody and before your trial begins. For example, in the Constitution itself, it says the government cannot arbitrarily detain you or indefinitely detain you without any specific charge. That's called your privilege of the writ of habeas corpus, and that's in the Constitution itself, Article 1, Section 9. The Fifth Amendment, the Sixth Amendment, the Eighth Amendment all have something to say about your rights and the limitations on the government's power in between being taken into custody and having your trial. Notice a couple cases over there on the right. We'll talk about those in later videos. During your trial, you have additional due process protections. Most of them are found in the Sixth Amendment. You can read them over here or on your handout. But there's a little bit of the Fourth Amendment protecting you during the trial, and a little bit of the Fifth Amendment protecting you during the trial as well. The only case in this video that appears over on the right is Mapp versus Ohio. It is not required by the College Board. However, the concept that's associated with Mapp versus Ohio, the exclusionary rule, is an important concept, frequently appears on AP exams, and will be discussed in this video. After your trial, your due process rights continue to protect you from government misbehavior, let's say. Most of it is covered by the Eighth Amendment, but there's still a little bit of Fifth Amendment protecting you there too. There are a couple cases there mentioned that'll come up in the Eighth Amendment video. And then just to make sure you get a complete picture of the idea of due process, there are things in the Constitution and in the Fifth Amendment that govern government behavior kind of completely outside the legal system. We call those extrajudicial prohibitions. You've already learned that the government cannot just pass a law declaring you to be guilty. That's a bill of attainder. The government cannot pass a law that says what you've done that was legal in the past is now illegal and you can be punished for. And then there's another little bit of the Fifth Amendment that is helpful also. So as you can see, different amendments kick in at different points in the process. The concept of due process is scattered all over the Constitution and the Bill of Rights. So now let's get on with the rest of the video.
No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation.
So some vocabulary terms that might need explaining from the Fifth Amendment. The word capital. Lots of words in English start with the words cap or CAP, and most of them convey the idea of someone's head or an entire person. In this case, a capital crime is a crime for which you can be punished by death. So capital punishment is a one way of saying the death penalty. So a capital crime is a very, very serious crime. The Fifth Amendment also mentions otherwise infamous crimes, which we would probably assume and interpret to mean serious crimes such as felonies. A felony is defined as a crime for which the penalty is a year or more in prison. So the first line of the Fifth Amendment that refers to capital crimes and otherwise infamous crimes is basically saying that that clause of the Fifth Amendment applies to really serious crimes. The word indictment, indictment, is pronounced indictment. It is a formal accusation of a crime. If you are ever indicted, that's a very bad thing because someone has gone to a lot of trouble to charge you formally with a very serious crime. And indictments are handed down by what are called grand juries. Now, if you can kind of picture in your mind a typical trial, you see lawyers, judge, the audience watching, the defendants, the witnesses, and off to the side is the jury. Well, there's multiple kinds of juries. The jury that you're imagining in that little scenario is called a petite or a petty jury. They are the ones who sit through a whole trial and listen to all the evidence and listen to the witnesses and decide who's guilty or not at the end. A grand jury is different. Grand juries do not sit and watch trials happen. Grand juries go through evidence before a trial and decide whether someone should be charged or not, whether a trial should go forward or not. If a grand jury goes through the evidence and decides there's enough to charge so-and-so with such and such a crime, then they will issue that thing that we covered in the previous slide. They will issue an indictment. They will formally charge someone with a crime. The Fifth Amendment is saying that for serious crimes, it's not just up to some prosecutor somewhere. The indictment has to come from a grand jury. Then there's the double jeopardy clause. The Fifth Amendment says, for the same offense to be twice put in jeopardy. That is prohibited. In general, the government cannot put you on trial multiple times until they get a conviction. This is to protect you from things that used to happen way, way, way back in the past. The king would just want somebody in jail and just keep putting them on trial until finally a jury says guilty. Well, in our Fifth Amendment, that can't happen. Being tried twice for the same crime is double jeopardy, and that is prohibited under our Constitution. However, there are exceptions. Remember, we have a federal system. You can be tried, let's say, for the same crime in federal court and or in state court. That is, if for some reason you're tried in the federal court and you're found innocent, a state court could, under certain circumstances, try you for the same crime, and that would not be considered double jeopardy. Another example would be a mistrial. If you have a trial and for some reason at the end of the trial it's decided that there was something wrong with the trial, the jury was biased or something, you can, and it happens all the time, you can go through a second trial because the first trial never came to a real conclusion. Another trial can proceed, and that is not considered double jeopardy. What other interesting thing? Sometimes a criminal trial can take place, and let's say someone is found to be not guilty. Depending on the state, depending on what the crime was, you might be able to be sued, let's say, by the victims of the crime that you officially didn't commit, but a civil trial, you can be sued by, let's say, the victim's family or something. Let's say you were tried in a criminal case for murder. The jury said not guilty. Depending on the state and the circumstances, the family of the victim might be able to sue you, and it's a civil case, so it's not being tried for the same crime twice because the criminal trial is the government doing it. A civil case is a private party, regular people, individuals suing you, and that's not the government, so that's not double jeopardy. And by the way, if you ever saw the movie, I can't remember the actress's name, but it's called Double Jeopardy, and the lady goes to jail because she killed her husband, except she didn't really, and eventually he pops up again later in the movie, and he kills her again, and she says somehow she can't be tried again. That's all baloney. It's just Hollywood. Doesn't make any sense. So, never mind that. Good movie, but it's legally preposterous. Another important concept in the Fifth Amendment is the idea of being compelled to be a witness against yourself, which the Fifth Amendment prohibits. The government cannot force you to give information or to testify against yourself. This is known as the SelfIncrimination Clause. If you've never noticed, the word incriminate, look at it really closely. Incrimination, right in the middle of it, is the root word crime or criminal. To self-incriminate is to say something that makes it look like you committed a crime. And the Fifth Amendment says you don't have to do that. You don't have to answer a question. You don't have to give information. You don't have to testify in court if you think the answer is going to make you look guilty. Originally, what they had in mind when they wrote this for the Fifth Amendment was that they don't want the government torturing you just to get you to confess. But it applies in other avenues too. Later in this video, you will be introduced to the Miranda case. You're probably already familiar with it because you know that if you get arrested in this country, one of the first things the police have to do is to tell you, you have the right to remain silent. That is putting into life this self-incrimination clause of the Fifth Amendment. Because of the Miranda case back in the 1960s, the Supreme Court says the police have to inform you of your Fifth Amendment right to stay silent. Now, that's before the trial. In the trial, if the issue ever comes up, if you're ever asked a question you don't want to answer, most defendants don't actually testify at trial anyway, but if the opportunity comes up and you don't want to answer a question in open court, in this country we call it pleading the Fifth, because it's in the Fifth Amendment that it says you don't have to answer such questions. Maybe the most important concept embodied in the Fifth Amendment is the concept of due process. The actual words in the Fifth Amendment say, nor be deprived of life, liberty, or property without due process of law. I can't stress how important this concept is, this due process concept is. It's kind of like rule of law. Those words never appear in our Constitution, but the entire document from beginning to end is all about the issue of rule of law. Well, here, due process is a similarly enormously important concept. Parts of the idea, like we've already covered, are scattered all over the Constitution, but here you actually see the words due process, and it's telling you word for word that the government cannot take away your life. Nice to hold on that for a while. Your liberty, usually you think of that as not going to jail, and your property, fining you, taking away things. The government can't do those things to you without due process of law, or going through all the necessary steps that we consider to be part of due process. Can the government take away your life, liberty, or property? Yes, but what does it have to do first? It has to go through something called due process of law, going through all the necessary steps. Notice life, liberty, and property is an exact echo of John Locke's listing of natural rights that we studied back in the fall. Originally, the Fifth Amendment, as we've seen before, like the rest of the Bill of Rights, was interpreted to originally only apply to the federal government. But if you've done your homework, you know that in the 14th Amendment, there is another due process clause that mentions the states. And so make sure you understand that the due process, not being deprived of life, liberty, or property without due process of law, appears twice in our Constitution. Here in the Fifth Amendment, where it originally applied only to the federal government, and then in the 14th Amendment, where it was then applied to state governments, which eventually led to the doctrine of selective incorporation. And the final clause of the Fifth Amendment is called the Takings Clause. Literally, it says, nor shall private property be taken for public use without just compensation. Compensation is payment. Just means fair, which means basically your private property can't be taken by the government unless it pays you fairly for it. Notice that it is not saying that the government can't take your property. It just says that if the government takes your property, it has to give you just compensation for it. The power of the government to take your property for public use is called eminent domain. That could pop up on a test, so best to file that away somewhere. Pretty much every government in the world has this power. It has to, because the government needs to build stuff. It needs land to build roads and schools and post offices and parks, and just about anything the government does, it needs land to do that, and it has to have this power called eminent domain to take land, as long as it's, and the Fifth Amendment says it has to be for public use. Now, there's been some recent changes to that, or at least reinterpretations of that, but we'll get to that later in this video. Now, there have been lots of cases over the years about various clauses in the Fifth Amendment. The two of them here are specifically about the Self-Incrimination Clause, one from 1936, a particularly brutal case that came out of Mississippi, where the police just brutally tortured suspects into confessing in extreme detail to murder. And when their appeal reached the Supreme Court said, well, obviously you can't do that. Notice that it was a state crime in a state court, so this would be evidence, again, of something called incorporation. In 1963, kind of a variation on the issue came up in the Lynham case. In this case, the local police did not physically hurt the suspect, but used false threats and to get the suspect to confessed to a crime. When that was appealed to the Supreme Court again said, nope, can't do that either. It doesn't have to be physical. It can be verbal. Either way, it's unconstitutional to do that just to get a confession. Probably the most famous case involving the Fifth Amendment's Self-Incrimination Clause is the Miranda versus Arizona case from 1966. This is one of the cases in your 23-page packet. You've probably heard of the Miranda case, the Miranda warning, being Mirandized. It comes up in a lot of different ways in our language now, in our culture. I won't go through the details of the case, but here the suspect, Ernesto Miranda, had committed a pretty awful crime, and the police didn't physically torture him. The police didn't threaten him with false punishments, but they did just for a long period of time berate him, question him, under very tough circumstances, questioned him until he finally kind of broke and confessed. Now, you and I know, because now it's 50-something years later, you and I know that you have a right to a lawyer and the right to remain silent. Ernesto Miranda didn't know that and never asked. So the police in 1966 felt free to just keep questioning until he broke and confessed. When he eventually did get a lawyer, his lawyer said, well, that doesn't seem constitutional, so he was convicted on the basis of his confession, but his lawyer appealed. It got to the Supreme Court, and the Supreme Court said, nope, just because you don't know you have a right to something doesn't mean you lose that right, which makes logical sense. Therefore, and this was pretty much a shock to the law enforcement community at the time and is still kind of controversial today, the Supreme Court said, you being police, have to warn somebody. You have to inform them of the rights that they may not know they have. And almost word for word, you've heard it 100 times in cop shows and movies, that the wording of that warning, you have the right to remain silent. Anything you say can and will be held against you in a court of law. You have the right to an attorney. If you can't afford one, one will be provided for you. That is almost word for word from the Supreme Court decision in the Miranda case. That's why it's called the Miranda warning, etc., etc. You can probably imagine how thrilled law enforcement personnel were that they had to go around before they started arresting people and asking them questions. They had to tell them that they had the right to shut up. But that is the law in the United States because of the Supreme Court's decision in the Miranda versus Arizona, 1966. Now, the lawyer part actually comes from the Sixth Amendment, which we'll cover in the next video. But the Fifth Amendment part, you have the right to remain silent, makes it a good fit for this video. Just as a sign of how this issue, even though it's become part of our culture and part of our law enforcement system for about 50 years or so, every once in a while it gets updated and reinterpreted. And in 2010, the Bergwas case, the Supreme Court kind of took a step back from the Miranda rule and said, well, if the police ask a suspect questions and the suspect maybe gives really short answers, yes or no, to a question here, a question there, but for the most part doesn't want to talk, just the act of answering a question occasionally, maybe giving a quick yes or no to some of their questions, that can be interpreted as giving up your Miranda rights to remain silent, etc. Bergwas was told he had the right to remain silent, but every once in a while would answer one of their questions, and his attorney eventually objected that his answers were used in court. And when the appeal reached the Supreme Court, a suspect has to actually say, "I'm claiming my Miranda rights," and then shut up. If the suspect then continues to talk a little bit here or there, then basically that means that the suspect has given up his or her Miranda rights. Two more cases that have to do with the Fifth Amendment, this time the Takings Clause. The first one is the first case in that 23-page packet you've been given, Barron versus Baltimore, which was talked about in the incorporation homework. This was the case where the Supreme Court, for the first time, had to interpret something from the Fifth Amendment as it applies to a state or local government action, in this case, the city of Baltimore. You can read about the details of the case on your own, but basically this case is important because the Supreme Court here said that the Bill of Rights does not apply to state and local governments, only the national government. So Mr. Barron did not get what he wanted from the city of Baltimore in 1833. Now, eventually, that all changed. As you know, the doctrine of incorporation came along, and most of the Bill of Rights was and is now applied to state governments. But a related case, because it has to do with the Takings Clause, is from 2005, Kelo versus the City of New London. The city of New London in Connecticut used the government's power of eminent domain to acquire private property. The Fifth Amendment says it's supposed to be for public use, and usually when we think of public use, we think of a school or a road or something. But in this case, they turned it over. The city of New London, Connecticut, turned that property over to private developers who I think turned it into a shopping mall or something. Which is not the government. It's private ownership. So the government in New London, Connecticut, took private property and using eminent domain, and then gave it away to other people to use as private property. The purpose was for economic development. There'd be more shopping and more tax revenue and blah blah blah. But this was challenged because wasn't quite what people thought of as public use. But when it got to the Supreme Court said, yep, that's okay. And it's still kind of a controversial decision. Some state and local governments have said, okay, now we can do more with our power of eminent domain. And some places in America have said, wait, that's a dangerous thing. Let's pass laws and make ssure we don't ever do that. But anyway, just threw that into the packet because I thought you might find that interesting. And the last case I wanted to quickly discuss is the case from 1944, Korematsu versus U.S. Now, technically, this is not a Fifth Amendment case. You'll see why in a second. But I want you to be aware of it because it is, in my personal opinion, that this is one of the all-time worst Supreme Court decisions ever. It's right up there with, Plessy versus Ferguson and Dred Scott versus Sanford. I mean, this is a terrible, terrible case. This is about the internment of Japanese Americans during World War II. After Pearl Harbor, part of our Navy was destroyed. The country felt defenseless. We were afraid of an invasion, an actual land invasion from the Empire of Japan. And first with a executive order from President Roosevelt, and then backed up by laws passed by Congress, Japanese Americans were required to leave their homes and businesses and basically serve out the rest of the war in what were prison camps. One individual named Fred Korematsu thought this was wrong, and he defied the curfew order. He did not report to the place where he was supposed to report. He was arrested. He appealed all the way to Supreme Court, and the Supreme Court, and this is kind of the scary thing about this, legal arguments basically never came up. The Supreme Court simply accepted at face value the government's claim that Japanese Americans were a security risk. There were risks of espionage and sabotage, and in case we ever get invaded, these people might help the invaders. It was pretty much outright racism. It was just a group of people were suspected of being disloyal to the government, and there was absolutely no evidence that was true on any level for any individual, let alone the entire 100,000 people group. the concept of due process never even came up. There was no evidence presented. There was no specific accusation against Korematsu. There was no charge. There was no crime listed other than he just didn't show up for his not deportation, but internment. So it should be a Fifth Amendment case because he was darn sure, along with a lot of other people, deprived of his liberty and property. But like I said, that argument never even came into the case. The Supreme Court didn't even go that far. All they did was take the military's word that these people were a threat, and therefore it was okay to throw them into prison camps. This is a stark reminder from the history books that in times of war and crisis, your rights shrink. It has happened and happens over and over again in our history. It's not a good thing. I'm not saying that this could ever happen again, at least not on that scale. But it is a reminder that don't take your rights for granted when in times of danger occur, in times of crisis. It happens all the time. Your individual liberties that are in some sense guaranteed by the Bill of Rights sometimes go away, at least partly. I also want to point out this case has never been explicitly overturned. There was a curious little thing recently in a separate case. You may remember when Trump took office, one of the first things he did was issue executive order banning people from coming to this country, from coming from certain countries. His first executive order on that issue was found to be unconstitutional. The second one, I think this is, the third version of that executive order, finally kind of stuck and made its way through the court system up to the Supreme Court. The Supreme Court said that's okay. His travel ban from certain countries at that time was constitutional. And curiously, John Roberts, the Chief Justice, who wrote the majority opinion in Trump versus Hawaii, you don't have to know that case. I'm just thinking you might find this interesting. Just kind of, not for no real obvious reason why he did this, but he just threw in a line about the Korematsu case and how he believed that it was very, very wrongly decided, which is good. Because that's definitely true. What's kind of interesting was that the case he was writing the majority opinion for was sort of about different issues. It didn't have any direct bearing on the Korematsu case, and the wording of what he said it was unclear in whether it should be considered to be overturning the Korematsu case. The legal world is kind of arguing about this. Has the Korematsu case actually been overturned, or was that just an opinion thrown in a separate case that it was a bad decision? Anyway, so it might be still precedent. It might not. I can't tell you definitively, but I thought you might find that interesting. So, none of the cases that I presented to you in this video are required by the Supreme Court. By the College Board for the purposes of the AP exam. But there's some language, there's some concepts, there's some vocabulary that I think would be very helpful in case that comes up on a question related to civil liberties. The word indictment is a formal charge by a grand jury, a special group of people put together to decide whether someone should be charged with a crime or not. That's different from the petty jury that decides the outcome of the trial. The grand jury decides whether there is going to be a trial by deciding whether there's enough evidence to charge someone with a crime. Double jeopardy, you know what that means. The Self-Incrimination Clause, you must, the Miranda case is not a required case, but the Miranda rule that suspects be informed of their rights is so important. I can't imagine that not being fair game, so make sure you know that, where it comes from. The Due Process Clause, absolutely got to know. There's a version of it in the Fifth Amendment, a version of it in the 14th Amendment. It means the government has to go through certain steps For example, give you a fair trial, whatever that means. Basically, these all 4 videos about due process are about that concept, before the government can deprive you of your life, liberty, or property. And then there's the takings clause, which involves the government's power of eminent domain. The government can take your property for public use. All the Fifth Amendment does is require the government to give you a fair price for your property. Make sure you catch us in the next due process video, which will be devoted to the Sixth Amendment. Thanks for watching.